This is a really tough story because you're looking at the living conditions that police say 6 children, including a 2-month-old baby, were living in, locked inside a storage unit. Their parents were found asleep inside their car outside the unit, and now they are facing serious charges. Just how much this couple was reportedly getting in Social Security benefits and what the mom had to say for herself in an emotional court hearing. We're on the case, presented by Law&Crime. I'm Chris Stewart. It is not easy to see the images I'm about to show you. Images of a storage unit that police say 6 children, including a baby, were living in for weeks. Police were called to this storage complex around 1:30 in the morning last week, Tuesday, September 16th. Someone had heard the sound of a child crying from one of the units. Now, Milwaukee police said when they opened the door to the storage unit, they found children living in this. And the ages of those children, 9, 7, 5, 3, 2, and a baby just 2 months old. Now, police say the smell was, quote, putrid. And you can see in this picture, there's a sectional couch, a mattress, some blankets, no sheets. Police say the only light was what could creep through the gaps in the door. There was no running water, no electricity, no way to call for help if there was a problem, which just brings me back to thinking of that 2-month-old child. Now, this is the other picture that police have put out of a bucket that was in the middle of that storage unit. And that's what these 6 children were reportedly using to go to the bathroom. Police then started searching for the people who locked these children in the storage unit, a place that's meant to keep belongings safe, not a place for human beings, let alone children, to sleep. And outside, they found a Ford Expedition, and inside of it, sleeping with their dog, police say was the mom and dad to these 6 kids, 33-year-old Charles Dupriest and 26-year-old Azyia Zielinksi. A criminal complaint reviewed by WISN TV, frankly, it just breaks your heart with what these children have reportedly told investigators. Here's what it says. The 5-year-old told police that the children were told not to be loud when they were in the unit. The 9-year-old said it was his job to take care of his 5 siblings and that he was hungry. He said that his parents drank, and when they were drunk, it was his job to look after everyone. Another child said that she was upset that the dog got to sleep in the car while she and her siblings were locked inside the unit. Prosecutors would later note how much space there was in the car where even a child could have fit in there instead of being allegedly locked in a storage unit. Not that it would have made it much better or that would be a proper place for a child to sleep. Now, one child, when asked how she felt when the storage unit was locked, said she was, quote, sad. The 9-year-old also reportedly said he and the other children would receive, quote, whoopings from their dad, Dupriest. Now, these parents reportedly told police that their children had been sleeping inside this unit for the past 6 weeks. The dad said the kids were sleeping there 3 times a week, and he did admit that they could have found a place with family or friends for these children to go to, but instead they allegedly decided that the storage unit is what they were going to do. Now, on top of the dirty and potentially dangerous conditions that the children were living in, police say they also found a loaded gun in the center console of the SUV that Charles and Azyia were sleeping in. Now, Azyia claimed that the gun was hers, but Charles had touched it. Both parents are facing 6 counts of child neglect, but Charles is also facing an additional count of illegal possession of a firearm by a felon. Now, we found in court records that in 2010, Charles was convicted of 3rd-degree sexual assault in Milwaukee County in Wisconsin, which is north of Milwaukee. Right now, all the children are in the custody of Child Protective Services. Dupriest and Zielinksi, they are facing those serious charges. And here is part of what the mom's initial court appearance was like per WISN.
We have your children stating that they had no food, that the only food they found was from the garbage.
Now you can see she was very emotional in that appearance. Some strong and frankly honest words from the prosecutor. She and Dupriest have said that they were homeless, that they were forced to live in these conditions because they were kicked out of a shelter in Milwaukee. But that shelter is pushing back on those claims. I'll get to that in just a moment. We did find that Zielinksi was actually still very much active on social media, so she had access to a phone while being homeless. Here's a post that she put up on September 5th, marking that she was 1 month postpartum. Now, it's unclear how long Dupriest and Zielinksi and those children had been considered homeless. Prosecutors say this couple receives about $2,000 a month in Social Security benefits. The couple also claimed, again, that they were kicked out of a shelter in Milwaukee. But that organization told WTMJ-TV that they verified that there was permanent housing secured for this family when they left the shelter. But now they're learning that the family never actually went to that housing. So they are disputing the claim that this family was kicked out of the shelter and the claim that this family had nowhere to go. They also said that there were several families that were helping this family and their kids. The Milwaukee Journal-Sentinel reports that Dupriest is a registered sex offender and that may have created a barrier for the family to stay in certain shelters. In putting this story together, we were working to learn more information about this couple and about where they may have lived in the past as we try to piece together the story of how they eventually made it to allegedly having their kids in this storage unit in Milwaukee. Now, we did find that they had an old address listed on truthfinder.com, but again, it's unclear when they left that address and what circumstances led to them allegedly being homeless. At Law&Crime, we partner with Truthfinder and we use it to get details on the people involved in our stories. But even if you don't work in true crime, it's a great tool that can give you some peace of mind, and it's one of the largest public record search services in the United States. And with the paid subscription service, you get access to unlimited reports about almost anyone. And right now you can get 50% off your first month of confidential background reports. Just go to truthfinder.com/OTC. Joining us now to talk about this case is practice professor of law at Temple University, Marian Bracha. Thank you for taking the time to be with us. I know the pictures of what the storage unit, what it looked like on the inside, and it's difficult for anybody to look at and think about the children that were allegedly that were living there. But from the prosecutor's standpoint, what are you looking for in terms of building a case now against these two parents?
Yeah, I think the photos, as they say, a picture, is worth 1,000 words. And so the fact that there is visual evidence that was documented about the condition of the storage unit, the size of it, what the children were expected to use in terms of hygiene and sanitation. I think that those pictures will be very powerful pieces of visual evidence for a fact finder to decide how these children were being treated, how they were expected to survive. And I think the other observations, the very evocative observations of the law enforcement officers who found the children will be also very persuasive and very powerful pieces of evidence.
And it's just shocking too, just the range of ages of not only just 6 kids, but it goes from 9 years old, and it seemed like he was in charge of looking after all his siblings. But there's a 2-month-old baby that was found in this storage unit, they say. And I know states differ, and this is Wisconsin, but I mean, someone who's 9, very different, still vulnerable, but very different from a 2-month-old child. I guess, how do the charges differ when it comes to the range in ages that we see in this case?
Yeah, well, there are enhancements, and I believe that 2 of the charges for each of the defendants have been enhanced and charged with a higher gradation because of the age of the children. So typically, I know in Pennsylvania, it's usually under 7. In some states, I believe in Wisconsin, the enhancement kicks in, if you will, when the child victim or the complaining witness is under 6. And so in this case, I believe there were at least two children who were under 6, including, of course, the 2-month-old child. And so that is considered a more egregious offense to neglect or abuse a child under 6 because of their vulnerability, because of their seeming defenselessness. And so those 2 charges, if I'm reading the criminal complaint correctly, have attached to each of these defendants.
How does, when charges enhanced like that, how does that impact what the punishment could be?
It could increase the punishment, because with the increased gradation, that means that there is a greater exposure. That means that there is a greater period of incarceration or supervision that a judge could impose, that there is a longer period of a punishment that is that each defendant would be eligible for.
And this couple, they said that they were homeless. And listen, homelessness is an issue in a lot of cities. It's an issue in Milwaukee, Philadelphia, Atlanta, wherever you go, and people are, they have kids and they're trying to do their best in a lot of cases. Typically, when prosecuting a crime like this, knowing that they were homeless, what do you look into? I guess how much does is there ever any grace that comes with that, and understanding that someone may not have the resources that other people have, like a house?
Absolutely, and I think that empathy and compassion are not lost on. I would hope that they're not lost on the prosecutors in this case, and I think they will be looking at the totality of the circumstances. They're going to look at what housing options were available to this family, what social services were made available to this family, what benefits or services they availed themselves of and took advantage of. I think the fact that they had been in a shelter previously and that there was housing arranged for them is going to be a significant factor that the prosecutors will consider. And the argument from the prosecutors will be that this wasn't a family, or that these weren't caregivers who did not have other options or other places to go, or other facilities where their children could live and thrive, that this was an intentional choice of the parents, of the criminal defendants in this case, to subject their children to the living conditions that were found by law enforcement.
Because there's part of it where, they're homeless, and obviously that's a major issue across the country on a lot of levels. But then even just within kind of the microcosm of when the kids were found, the parents were in the car and they were with a dog. And even prosecutors during a court hearing had said there was room in the car. And again, that, I don't know how much that would have made it better. I mean, you never want a child to be sleeping in a car, but at the same time, how could that element of it push back against the defense of, hey, they were homeless, they had nowhere else to go?
Right. I think that the fact that the dog was in the car with the parents, I can hear the argument from the prosecutor that, an animal's life was prioritized, or an animal's comfort and well-being was prioritized over their 6 children. But I do think that will factor in, that at least for the 2-month-old, why wasn't the 2-month-old swaddled and being held by the parents? Why was the 2-month-old given over to the care and custody of the other minor siblings? So I think the fact that there wasn't at least a parent physically present in the same facility, in the same setting with the children, is going to be a significant fact. The fact that the parents chose to afford themselves separate accommodations, if you will, and that they chose to stay with the dog as opposed to maybe putting the dog elsewhere or giving the dog to other caregivers. I think those are facts that will not reflect well on the defendant's choices in this case.
Because then I also think of the charges they're facing, and I just have Charles up here where he's facing these neglecting a child, and it is 6 years. And it says in parentheses, no harm and child under 6 years or disability, which is looks like a class I felony in Wisconsin. I know a lot of people might look just on the outside of, especially a 2-month-old being in these conditions. There's a bucket that these children were allegedly using to go to the bathroom. I mean, it sounds abusive almost to keep a child locked in a storage unit like this. What is the difference legally between someone facing a charge of neglect, but then someone facing a charge of abuse?
Well, I think that the difference is intentionality, right? And neglect would mean that that there has been negligent conduct, that there has been some absence, that there is some lack of caregiving that is expected of a parent or a guardian or someone in a caregiving capacity, and that those reasonable supports and that level of caregiving that we as a society would expect to be given to children was lacking in this case. With abuse cases, we're typically looking at an element of intent, of specific intent to cause or to inflict bodily harm, or to do something, and a conscious act that would deprive a child or another being of what they need to live and to survive. And so I think that in this case, there's an argument there could be an argument on both of those fronts for both abuse and neglect, because there was a conscious decision made, the prosecutors will argue, to place these children in this storage unit under these circumstances, lacking the facilities and the other indicia that we would expect for the safety and the well-being of children, and there was a conscious decision made to deprive the children of those affordances. And I think that I could hear the prosecutors resting on that for their abuse charge.
Another part of this too that sticks out to me is that it was locked. That, you know, you had something that was closed. This was not like an open garage that a child could even walk out of, which again, that wouldn't have made the situation any better in a lot of ways. But when it comes to arguments that prosecutors could make, because I know in cases in very different circumstances of someone allegedly being held captive, let's say, whether the door is locked, they had the ability to walk out. I've heard defense attorneys argue against that. In this case, there was no way for these kids to get out. And it's summertime, I think in Milwaukee too, where it does get hot. I guess that part of it, how critical could that be to the prosecution's argument?
I think also a very important fact. And yes, it's hot. Yes, it's Milwaukee, but also in the case of an emergency, there was no way for the children to reach their parents. There was no way for them to call their parents. I believe even the oldest child described that the only light that would come in was through cracks in the bottom of the garage type door of the storage unit. So this is really a dangerous and scary scenario for the children, and I think that all of these factors are going to be facts that the prosecution really highlights to prove their case.
You know, in storage unit facilities, I mean, they're not, I guess, high traffic areas where, you know, people are regularly seeing, but I guess they were staying here for several weeks, the parents had said. When it comes to looking at if someone had seen, and I don't know if this is the case, but I mean in terms of someone else who could face charges, because how are these kids in this storage unit for several weeks and no one was able to see them? I guess what type of investigating could be done to try to figure out whether someone could be in some ways complicit in the eyes of the law for this going on for such a period of time?
Right. Well, I would hope that investigators are looking at the entirety of the physical plant, the physical location where the storage facility is located. Are there surveillance cameras? Are there key cards? Is there key card access? Who is permitted onto the property or near the individual storage units? What information did management have or should they have had about the renters and what the actual units were being used for, what access the owners of the unit or the renters of the unit were making, and at what time and for what length of time. So I think those are all questions that the investigators can ask of the facility itself to determine who knew what or who should have or could have known what, and who could have or should have done something to come to the aid of these children if in fact there was information available to others who could be deemed mandatory reporters.
And I know the children now are in the custody of a social services organization in Wisconsin. What does the future look like for them, for kids in these types of cases where now they're in the custody of the state?
Well, I think that there are as varied outcomes from our foster system and from our social services that as there are children in the system, unfortunately. I think that things could end really, really well for them. And I think that there are plenty of stories of not so happy endings. And so I think first and foremost, the prosecution will have to consider what, if any, testimony they will require from the children who were involved in this case, because to an extent, the law enforcement officers who had eyes, so to speak, on the storage unit, who made the observations, can only testify to so much. They can only testify to the conditions they found on that particular day when the children were discovered. But in terms of the long-term experiences of the children inside this storage unit, what their day-to-day looked like, how they went to the bathroom, how they cared for each other, how they were feeling while they were locked inside this unit. Those are facts and are pieces of testimony that can truly only come from the children who experienced it themselves. And then, of course, Chris, we can get into a much longer conversation about the trauma that can be done to children having to testify against their parents and having to live out this courtroom experience, and also then the legal battles over which children would be considered competent to testify, the experience of being cross-examined, the experience of having to confront one's own parent in court. So this is just a truly sad and disheartening situation for everyone involved, but most certainly for the children who were discovered.
Well, and that kind of leads to my next part is it seems like, and we've heard the prosecution side of the story, it seems from at least the mom's court hearing, she was in tears, kind of realizing it appears what she was being accused of. And I mean, it's just a terrible situation. What would the defense be in a case like this where it does seem they have the pictures, they have children who have said that they, didn't like the situation they were in. As a defense attorney, what is the best approach to take in a case like this?
Well, I think the defense would rest on the fact that they were trying to keep their family, trying to keep their children together, that they were trying to keep them safe and corralled, if you will. They were keeping them all in one place. They were keeping them in a unit that was locked so that the children couldn't wander off and that no one else could have access to them or do anything harmful to them. I know, Chris, you're a parent, as am I, to imagine locking a child in a storage unit, especially a 2-month-old, with no adult there, or with no supervisor there, with no caregiver there, is unspeakable or unthinkable. But I think the defense in this case would be what you alluded to earlier, that these parents were doing the best they could under the circumstances that they were facing with the means that they had, and that they were doing everything they could to be near their children, to keep their children safe, and to give them, to put a roof over their heads in the only way that they could or that they knew how. Whether or not that is a defense that is plausible or one that is sympathetic will be up to a fact finder, of course.
Yeah, absolutely. Because I think especially, just kind of being a parent, like once you have a 2-month-old, you realize how small and vulnerable a 2-month-old can be, which just makes this story stick out so much. How likely is it that these parents, they're facing these charges, if they were found guilty, that they would face prison time?
Well, I think prison or any incarcerative sentence would be certainly up to the judge. It would be up to the circumstances of a guilty verdict, whether it came as part of a negotiated plea or whether it was after a trial, either a bench trial or a jury trial. And I think that the Wisconsin sentencing guidelines will come into play, and any prior record score, any prior sentences or convictions on the part of either defendant will be factored into what their potential exposure would be. So at this point, there's really no way to know until we see a final disposition in this case, and until the judge has a more robust dossier on each defendant to show what their criminal history is, if there has been one at all.
All right, and we'll see what happens next. Marian Bracha, it's always great to have you on Law and Crime. Thanks for talking through this very sad story with us.
Thanks, Chris. Thanks for having me.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.